Is the audience ready? Thank you. Appreciate people getting back promptly, and my apologies for being a few minutes late. The people that caused me to be a few minutes late know who they are. We are still, I think, on track to finish before 4 o'clock, but we'll take as much time as we need to go through. The next agenda item that we have, where's my clicker, is responsible vendor training. Mr. Executive Director, are you going to introduce this, or is there somebody on the staff that you prefer to do that?
Mr. Chairman, I'm happy to introduce it. Dr. Johnson is actually going to come join us for any questions.
Great. Fantastic. Welcome, Dr. Johnson.
Happy to jump into it.
If you'd give us just an introduction, that would be really useful. Thank you.
Yep, and then I'm happy to present as well. But I do want to start off by actually thanking our team that has worked on this, I think, pretty diligently. So Dr. Johnson has really led the effort for the commission, but it has been a team effort, including Matt Giancola, our Director of Constituent Services, as well as Patrick B.A., our Director of Investigations. So as the commission will recall, around July 1st, we launched the application for responsible vendor training. This application allows for vendors to identify themselves that want to be accredited as being able to offer the responsible vendor training programming. To date, we've received about 12 applications for that program. You have 4 applications before you for consideration. Any applications that are not before you, we are engaged with those applicants and working through other information that may be necessary for us to complete the application, hopefully bring it for you before you for your consideration. So today we do have 4 applications that are recommended for that approval. This would then allow those vendors to make themselves available to our marijuana establishments, including the managers, agents, and other employees. So
I was just asked for a timeline. If we were to approve one or all of these, what would be the timeline for implementation?
I think we want to work with those vendors to make sure that they have the facilities in order and that their curriculums are ready for launching. So I'd be difficult for me to give you a specific time frame at this point.
Thank you.
As part of the review, I think it's worth mentioning that we do review all the materials that are provided for us. We also, as you hopefully will recall too, that these responsible vendor trainers may not be affiliated with applicants or licensees as well. So there needs to be a clear distinction between them. We review that as well as ask for them for an attestation to that effect as well. Other materials that are include outlines of the programs that they intend to offer, as well as any of the materials that they intend to include relative to different sections that include marijuana's effect on the human body, diversion prevention and prevention of sales to minors, compliance with all tracking requirements, key state laws and rules, testing materials, and lastly, evaluation materials. We also ask them for how long they expect these programs to take, as well as what the examination at the end will look like. So again, that is the materials that we as a staff, including and specifically Dr. Johnson, Matt Giancola, and Patrick B.A. all reviewed. And the 4 that are before you today for your consideration. If you'd like, I can go through those.
Let's go through them one by one, unless there are questions about the process of the commissioners. And my thanks also to Dr. Johnson for her leadership on this. So let's go through them one by one for the 4 that are up for discussion and vote. Starting with quality analytics.
There you go. So the first entity that is proposed for approval is Quality Control Analytics. The contact identified is Ashley Boucher. The recommendation here is that upon review, the review occurred on September 16th, 2019, the Commission staff does recommend that Quality Control Analytics be approved for a 2-year certification to provide responsible vendor training. This recommendation is based on the review of those materials. Quality Control Analytics, the program is including both implementing an in-person training conducted on the premises of establishments, as well as at various local conferencing locations. And then secondly is an interactive classroom training via the platform Vadamo. This course intends to target all owners, managers, and agents of establishments. The course is expected to take about 2.2 hours to complete. An expected time frame for exam was not provided in this context. Again, as I indicated, we review the general content. We also look for those attestations around that certainly commission staff can attend and audit these programs, that they have every intention of complying with the requirements that they must update their training materials within 20 days of a change in our regulations. They have an obligation to be aware of any changes to federal state laws as well, and that no owner or employee of this entity has an interest in a marijuana establishment. And as I indicated, we also evaluate their course materials in those various stages, or the various sections. again, myself or Dr. Johnson have any
Sure.
questions.
So let's ask the Commissioner, are there any questions with respect to quality control analytics in the staff recommendation? Okay, then could I ask for a motion, please, to approve the staff recommendation to approve quality control analytics as a responsible vendor trainer?
So moved.
Have a second, please?
Second.
Let the record show that Commissioner Doyle made the motion to approve, seconded by Commissioner McBride. All in favor?
Aye.
Commissioner Flanagan?
Aye.
I'm sorry, I didn't hear you. So let the record show that the Commission unanimously approved quality control analytics as a responsible vendor trainer. The next applicant is Cannabis Trainers. Mr. Executive Director?
Sure, thank you, Mr. Chairman. Again, the entity here is Cannabis Trainers. Contact in this context is Maureen McNamara. Also reviewed on September 16th. Commission staff recommends Cannabis Trainers Sell Smart program for 2-year certification. I should also indicate the regulations allow for 2-year certifications. That's what that stems from. For Cannabis Trainers to provide responsible vendor training. This is based on a review as well as their compliance with our regulations. This program has been providing cannabis training since 2014, primarily in Colorado. If certified locally, they intend to implement a Sell Smart program in both an interactive classroom setting as well as an interactive virtual online webinar via Zoom. They intend to target all owners, managers, and agents. This course is expected to take 5.5 hours to complete, including 6 quizzes as well as a 40-question examination. Again, we reviewed the general content as well as identifying and securing those attestations, and lastly reviewing their materials for each of those 6 sections.
Thank you. Are there questions for Executive Director Dr. Johnson on Cannabis Trainers?
Can I just
Yeah,
ask one
Commissioner
question? And you may not know this. Was there a was there a number of in regards to the applicants? I guess are there more out-of-state people applying to provide these services versus in-state? Did we even look at that? I'm just curious.
Well, we do look. I don't know, Dr. Johnson, if you have a breakdown though.
I believe there was 2 out of. Oh, sorry. I'm sorry, Commissioner Flanagan. I think there were 2 out of state on this of the 12. I could be wrong on that. Let me check and get back to you on
That's
that.
fine. Thank you.
Absolutely.
Thanks. Any other questions or concerns? Okay, then I'd like to ask please for a motion to approve Cannabis Trainers for the responsible vendor training program. Can I have a motion, please?
So moved.
Can I have a second, please?
Second.
Let the record show Commissioner Doyle made the motion to approve, seconded by Commissioner McBride. All in favor?
Aye.
Let the record show the Commission unanimously approved Cannabis Trainers for the responsible vendor training program. The next is Stoker Consulting, LLC. Mr. Executive Director.
Sure, thank you, Mr. Chairman. Again, this entity is Stoker Consulting, LLC. The primary contact is Mr. Richard Gilbert. Again, also reviewed on September 16th. The Commission staff recommends that this entity be approved for 2-year certification to provide responsible vendor training. Again, it's based on a review of the materials as well as their demonstrating compliance with the regulations. If certified, they intend to implement in-person training to conduct on the marijuana establishment's premises or in a rented business facility. The program intends to target all owners, managers, and employees of establishments. This program takes approximately 2.25 hours to complete, as well as a 30-question multiple choice online examination taken and proctored by the presenter. Here in this instance as well, we also reviewed all the general content, secured those attestations, and reviewed the materials associated with the 6 sections.
Thank you. Are there questions about Stoker Consulting, LLC? Then can I ask please for a motion to approve Stoker Consulting, LLC as a responsible vendor trainer?
So moved.
Can I have a second, please?
Second.
Let the record show Commissioner Flanagan made the motion to approve, seconded by Commissioner Doyle. All in favor?
Aye.
Let the record show the Commission unanimously approves Stoker Consulting, LLC as a responsible vendor trainer. And finally, Anthony Bartuka, Mr. Executive Director.
Thank you, Mr. Chairman. Again, the entity here, or the individual and entity, I suppose, are Anthony Bartuka. Also reviewed on September 16th, Commission staff recommends approval of this application for responsible vendor training. This is based again on the review of the materials as well as the compliance with our regulations. This program plan intends to implement in-person training at the establishment's premises or an entity that's convenient to the establishment. They intend to target all owners, managers, and agents of the establishment. This training is intended, or It's expected to take about 2 hours to complete, plus a post-course 20-question examination. Again, the evaluation is based on the general content, the attestations that were submitted and secured, and lastly, review of the 6 sections for course materials.
Thank you. Are there any questions or comments on Anthony Bartuca? Great. Then can I ask please for a motion to approve Anthony Bartuca as a responsible vendor trainer?
So moved.
Can I have a second, please?
Second.
Let the record show Commissioner Flanagan made motion to approve, seconded by Commissioner Doyle. All in favor?
Aye.
Let the record show the Commission unanimously approved Anthony Bartuca, as a responsible vendor trainer. Can I ask a question, please? So there are 8 more applications that have been reopened, or where we've requested additional information. Can you just kind of tell us the process and the timing, please, Dr. Johnson?
Yes, absolutely. So the other 8 applicants have received an email yesterday requesting additional information, and so we will be reopening that in the next round of reviews.
Okay. And do you have an estimate of the number of trainers that we'll need to support the industry?
At this time, I do not. That's a calculation I can work with to try to figure that out. Yes.
Thank you. Commissioner Tuttle?
I have that question.
Okay, well, again, thank you, Dr. Johnson. Appreciate it. This is obviously an important step, so we really appreciate your leadership on this. Don't go too far, since I think you're back on the agenda in a little bit, so thank you.
Can I ask a question?
Yes, go ahead, Commissioner.
Someone
Bryant.
refresh my memory on by what date marijuana establishments and agents need to have this training in place, because we had moved that.
Mr. Executive
right?
Director?
January 1 of, I think it was 2020.
I think that's my recollection as well.
And I should also mention to you, Mr. Chairman, that the application is open for responsible vendor training, so it's not, the universe is not limited to those 12 total applicants. So we would encourage anyone that believes they can offer a program to obviously review the application materials. There's information on our website, and so by all means, we would encourage anyone to apply.
I would appreciate a follow-up on the question I asked Dr. Johnson, which is how many do we think we need to support the program statewide? You don't have to answer now. I just appreciate some thought to that.
Sure, but I think that's going to be dependent too on a lot of different factors that are very difficult to ascertain.
Just make, well, but you're smart.
And
busy.
I have another question.
Go ahead,
So
Commissioner Bryant.
how are we following up with the trainers that we certify to make sure that as we change our regulations, that those components are embedded in what they're providing?
And so, I guess, Dr. Johnson, let me get ahead of you a little bit, I guess, which is certainly maintaining a contact list of those entities that are certified, as the regulations or laws, for that matter, are adapted, changed, modified, you name it. I think our intention is to circulate that information. There is a requirement in the regulations that they update their materials, their training materials, based on those changes within 28 days, and submit it to the Commission for evaluation as well. I don't know, Dr. Johnson, do you have more to add to that? Or?
And when we're reviewing them, we're looking at the accuracy of the information that they're providing.
Yes, and if any changes they have, again, that time frame that they have to make those changes, and also we have like a secret shopper, so any commission staff without notification can attend any of these trainings without notice.
Thank you. Any other questions? Commissioner Tuttle?
First, let me thank Dr. Johnson and Matt and Patrick, thank you, and Commissioner Doyle for all the work on this. And I offer this with the humility that I did zero work on reviewing this. I don't know how much work this would be at all, but I got several emails, and I'm sure everyone else did too, from veteran-owned businesses and social equity program participants in the ancillary track who had applied and were disappointed. And it looks like if they did apply, they still have a chance in the next round because their application will be reopened. And we don't have to decide right now, but I wanted to raise for consideration if we might consider giving expedited review to those same categories that have expedited review for our licenses.
The process for reviewing these is really a group team effort and done in bulk. So all 12 applications were reviewed together in a way. So the universe is small enough at this point. But I think your point is well taken as far as kind of prioritizing the evaluation. I think it's dissimilar from our licensing process in that that generally has one person in it at a time, whereas this is more of a collaborative approach. That said, I think going through this first cohort, the takeaway here is, and the concern I would have is Dr. Johnson, Matt, as well as Patrick are also busy with their respective roles as well. And I think I would like to actually entertain and consider staffing this and other training elements of the commission, including, say, for instance, seed-to-sale tracking or metric, with an individual that can then spearhead the effort of compiling the resources. I do not want to, I think to Commissioner McBride's question as well, which is the materials included in a responsible vendor training context are vast, and they really, I think having a variety of folks from across the commission involved in the review of those materials is imperative, but having one person accountable for the coordination of that effort, I think, is also imperative, so that these things do not fall through the cracks, and so we're able to do that. So I think what I will commit to do is, as we continue to evolve as a commission, as well as specifically through responsible vendor training program, is to bring those things into consideration for how we staff it and support it. And if there's an opportunity to bring that approach, I will certainly entertain that.
Thank you.
Thanks. Anything else? Okay, thank you. We now are into the section about the set of issues and topics for the commission to discuss and vote on. I'll lead the first one, then I think Commissioner Doyle and Commissioner Title will help me on subsequent ones, but let me start with the next regulatory cycle. Let me start also by thanking our General Counsel, Christine Bailey, for leading this process. So just for context, for people that don't live and breathe this stuff 7 days a week, 24 hours a day, we just finished a regulatory cycle, as you were all aware, but we agreed at that time that issues that got raised that we could not address in this most recent regulatory cycle, we would address in a specific time frame in the near future. We have set a general timeline that we will start the next regulatory round in January of 2020. And we need time between our last round and January of 2020 for several reasons. One is we need to implement some of the changes that were made in the last regulatory round, and that takes time and takes staff attention. Two is we need to do some work. We need the staff to do some work on some of these regulatory issues. So the purpose of the conversation today is not to finalize the list of things that we are going to take on in 2020, but to at least put together a starting point so that we can ask the staff, where necessary and appropriate, to start doing the background work necessary so that we can discuss these issues in January, starting in January of 2020. So the objective here, again, is not to have a final list, not to say it's not going to change, not to say that we won't add to it if necessary or maybe take things off, but to give some guidance to the staff so that we can start doing the necessary background work over the next few months. My objective in putting this up today is just to make sure that none of the commissioners feel like anything's missing, and that if there is a need to get the staff focused on something for 2020, that it's on this list. But I don't want anybody to assume this is a final list that can't change. That is certainly not the intent. The intent is just, again, to give some guidance to the staff. With that being said, General Counsel Bailey met, I believe, with each of the commissioners individually over the last few weeks, worked with the executive director, and has come up with the list that was circulated earlier. I don't feel a need to go through the list. I do feel a need to ask each of the commissioners whether there's anything missing. And again, this is not things that you want to make sure are on the list in 2020, but things that you think the staff needs to be working on to prepare us for the next regulatory cycle. So can I just ask each of the commissioners if there's something missing here, or something misstated, perhaps? Commissioner Flanagan?
Mr. Chairman, I would like to have the topic of edibles added to this list.
Can you be more specific?
No.
No?
I want to take a look at what we have for regulations for edibles. I want to look at the entire section. I don't want to run into the situation where we haven't warned the public, so we're not going to take a look at it. So I would like to have the whole topic of edibles added.
Fair enough. And to the extent that there's staff work that you think is required, no, I'm just...
We'll work with staff to do that.
That's all I'm asking. That's fine. Anything else, Commissioner McBride?
I'd like to add research licenses.
Can you?
Do you want to?
I would like you to.
Hear me?
Sorry.
I would like you to. Then when you make your final comment, you can drop the mic.
I'd like to add research licenses, please.
Thank you, Commissioner McBride. Can you be more specific for me, please?
No.
Just because Commissioner Flanagan said it doesn't mean you have to say it. Thank you. Commissioner Doyle, I'm sorry, I'm a little bit. What'd you call me, hangry?
You're hangry.
Commissioner Doyle.
This is actually just, I think, probably a little oversight. Sampling I had meant to be under both medical and adult, and I think it only appears on the list under adult, so I just wanted to clarify that.
Christine. Okay, thank you. Anything else? Commissioner Fennell.
Just 3 hopefully quick clarifications. One is, I was just wondering what was meant by impairment under operational requirements.
General Counsel.
I think it goes to some concerns were raised about the ability of, I think the ability of certain retail locations, probably social consumption locations, to evaluate the impairment of individuals.
Okay, thank you.
Commissioner
So regarding vaping, so earlier in our early September meeting, we had talked about our short-term plan with the most recent regulations, and then our longer-term plan in terms of surveying licensees, reviewing testing capabilities, and coordinating with other regulators. So between now and the next round, even though we're barred from regulating vape products right now, we can still move forward with those plans. Is that right?
Yeah, why not?
Okay, thank you.
You have another question?
Yes, the
Go ahead.
third one is with regard to labeling. I think the IE edibles might have been something I said. I was referring to how there's new research in the past few years with how customers read edibles labels, but I would actually just like to review labeling in general. So if we could either remove that or make it EG edibles.
Yeah, I think there was, yeah, absolutely. The packaging, labeling, product design, we see it as a general overview of everything.
Thank you.
Great, thank you. Anything else? So again, I want to thank our General Counsel for her leadership here. I want this to be kind of a living list as we get closer to January, so I would appreciate everybody working with Christine as a point person. To the extent that other issues come up that you think need to be addressed in this round, please get to her as quickly as possible, and she's going to be the repository of the living list that we'll work on between now and January, and then use as the basis for our discussions in January. So, thank you again, General Counsel. And I want to make sure we're all set. Move on to the next agenda item. There's no vote necessary here. The next agenda item, I'm going to ask Commissioner Doyle, please take the lead on, and this has to do with some concerns and suggest changes that Commissioner Doyle has raised with respect to priority RMD status. Commissioner Doyle, if you would lead this part of the conversation, please.
Sure, thank you, Mr. Chairman. Essentially, I just want the Commission to have a discussion about priority RMD status as I have been reviewing how RMDs are progressing since they have received their provisional license towards operational, particularly those that are enjoying priority RMD status. In discussions with staff members, I have discovered that there is not necessarily the same view of priority RMDs in the Commission, and I thought the 5 of us need to talk about it, and the only way to do that legally is in a meeting. So my own personal view was that priority status was given to RMDs by the legislature so that they would be able to open more rapidly, as they had already gone through the DPH application process and possibly the inspection process, and may even be up and running. And in fact, in the legislation, if we had not filed our regulations by the statutory deadline,
Which we did.
but we did, they would have been authorized to automatically commence adult operations wherever there was a medical RMD.
And I believe that was where the fallacy that we were supposed to have stores open by July 1st came from, which is that if
That
we didn't
was
have
it, yeah.
regulations by March 15th, they could open by July 1st. Is that correct?
Well, I don't know where the fallacy came from, but your assessment
I
of...
believe that is where the fallacy came from.
Yes.
Keep going.
So that was my view of what the intent of the legislature was. Obviously, I was not part of it, but I believed that the idea was that RMD status was to enable entities that were already well on their way to being open would be able to add adult operations to medical operations that they were either working on or already had operational. And so to carry that logic through, in my mind, I thought priority RMD status should be limited to locations that have a provisional or final license as an RMD or are operating as an RMD. And if the RMD status of a particular location was expired, then that company would not be entitled to priority RMD status for that location for an adult license, and instead would be considered a general applicant. And that if a company has priority RMD status for locations, it is limited to those locations where it has RMD licensure and for those activities that are covered under RMD licensure. In other words, if we on the adult side have a license type that doesn't have a medical parallel, that priority status does not extend to that additional license type. And so I realize that is my view, but that may not be the view of the other commissioners. So I just wanted to talk about it, and if we are all in agreement about how priority RMD status should be implemented, maybe we could request that the executive director and the team implement any changes necessary to ensure that how priority RMD status is being executed is consistent with the policy of the commission.
Thank you. I appreciate you raising this important issue. Can I ask the other commissioners for their thoughts? Well, I can ask. Will anybody answer? Commissioner Powell.
I agree with Commissioner Doyle's interpretation, and I appreciate her bringing this up.
Thank you. Other commissioners? While they're thinking, can I ask your opinion on something, Commissioner Doyle?
Sure. I just realized that I actually forgot to ask the executive director if he could provide any,
oh, that's right.
any facts and numbers that would assist us in
that's going to be relevant to my question,
yeah.
so I think that's perfect, Commissioner, or Mr. Executive Director. And that you did circulate this yesterday to the Commission. Just go ahead, if you wouldn't mind. I don't think we have a slide of this.
There's not a slide.
No, go ahead. But it will be included in the materials that we post later today.
So I think just to illuminate the conversation or try to capture the universe, and this information is not so immediate as far as the most recent data, but it's there of 214 applications that were surveyed in our portal. All 214 have received at least initial review. 151 of them, so 70%, are proposed co-located with existing RMDs that have a PCR or FCR at that location. 58, or 27% approximately, are not proposed to be co-located with the RMD that have a PCR or FCR. 5 were for license types that are not do not have a parallel in the medical program that includes research or transportation. And 34 have been reviewed based on their RMD priority certification that are not co-located with the PCR, FCR, but have not yet been considered by the Commission for licensure. So the universe that would be affected by this change would be those 34.
But is it fair to say we have issued licenses in the past that were not co-located?
That would be the 27% or 58 total
okay.
applications, or now licenses.
That are now, okay. So that's my concern, and what I'd ask for your thoughts and opinion on, which is, just kind of the question of fairness.
Absolutely. Had I figured this out earlier, I would have.
No,
acted
I'm
earlier.
not. But
yeah,
please,
but
I'm not
it's
being
true.
critical at all.
Yeah,
I just because I agree with Commissioner Title that I think that your interpretation is the same as mine, but I am concerned about precedent and fairness.
Yeah. No, and I understand that, and I'm actually going to do something lawyers don't usually do, which is provide a counter argument for my own proposal. There is something to be said. I know. law school professors right now are cringing, I'm sure.
What do you think, Professor Steiner, what do you think? Is she showing you that her training was suspect?
So the downside to what I am proposing is that there are certainly applicants who are well prepared to open new locations that they don't currently have medical operations for, and they have an experience that newer applicants may not have. So they do bring an asset in their experience to the market. Where I struggle is whether or not that is appropriate to give them priority status, or whether they should, for those locations, or whether they should simply be general applicants and be in with everybody else in terms of how quickly the application for that location is dealt with.
Yeah, but I appreciate what you said, and I agree with it. I don't know that it explicitly addresses my concern with that we treated people differently in the past. Mm-hmm. So that'd be interested in your thoughts about that.
We can, as a commission, change policy proactively. I am not one that wants to tie myself to something that we've done in the past, where we've figured out that perhaps it would be more appropriate to streamline, if that is the consensus of the commission, or whether we should simply go as we have apparently been going with providing the priority RMD status to those who have earned it, but perhaps not for a particular location or license type.
Other comments? I guess in lieu of further discussion, would you like to propose a motion?
Sure. At the risk of putting even more on their plate, and I apologize in advance for that, I move that the commission request the executive director to implement any changes necessary to ensure that priority RMD status is limited to those who qualified in April 2018, limited to the locations and activities for which the applicants have RMD licensure, and require that RMD licensure must be maintained to be eligible for priority treatment for adult licenses for that location.
Any comments or questions before I ask? Well, first of all, can I have a second to that motion?
Second.
Any comments or questions? Let the record show that Commissioner Doyle made the motion, seconded by Commissioner Title, or I ask for a vote. Any further comments or questions? Okay. All in favor?
Aye.
All opposed?
We all said aye.
But I said aye. I just want to make sure. Let the record show that the motion was approved by a vote of 4 in favor. Commissioners McBride, Doyle, Title, and Flanagan. Commissioner Hoffman voting nay. Thank you very much. Mr. Executive Director, do you have any questions or comments in terms of what's been asked of you?
No, aside from, this is going to, I think, require some, I'll work with staff. I think notice will need to be provided for any licensees or applicants, I should say, this may affect. As far as process and what I need to develop in order to accomplish this as well, or I guess a statement as well, which is also applying to all of this, is the license limitations as well, as far as 3 per each type per entity. That has applied consistently throughout, so I think just want to make sure that's clear too, that there's not a violation of that cap. We'll get started in earnest on this. I just want to be able to capture that universe. As I said, I think there's 34 that have been reviewed, have received their initial review. At this point in time, there are no priority applicants currently that have not been reviewed by the Commission.
I'm aware of that.
That does include, though, for instance, some potential RMD priority, or now MTC priority applicants that have been reviewed and reopened. Because they've secured that initial review, when they do return to the portal, it would be my intention to maintain that status, as we've already evaluated them once. So this, I think, would apply prospectively, if that's the intent of the Commission.
Can I ask a question, Mr. Chairman?
Sure, please.
So just to make sure I'm understanding what you're proposing. So they've secured their initial priority review. It has been reopened, and this is more a question about how applicants that have reopened applications that have been resubmitted to respond to the request, how they are reviewed in order by the licensing team. So if you receive on a given period of time a number of applications that are resubmissions, do you sort the priority categories up front and then they are reviewed first before the remaining?
That's correct.
But if they've already, if I'm understanding correctly, you've represented that all the priority RMTCs have received initial review.
Correct.
So if we already have given them all initial review, does the vote become meaningless if we're still maintaining the priority for resubmissions?
It does not become meaningless in that priority applications arrive on a regular basis, on a rolling basis. So, for instance, if a new application was submitted to the Commission using the RMD priority status for a location that was not affiliated or associated with an existing medical certification, we would evaluate that and they would be deemed a general applicant based on this policy, not a priority applicant. So if you applied tomorrow with a new application.
And I'm sorry, you may have given us this number already, but it's slipping from my mind. Thank you. So I'm trying to figure out how many applicants we have in the known universe that may have an RMD, PCR, FCR that are potentially eligible for priority RMD treatment that have not yet actually submitted something on the adult side.
That is unknown to me at this point.
Okay, thank God, because I couldn't remember the number, and I'm grateful there's a reason I don't remember it. Okay.
But that's actually, to your point, that this is a limited universe by default. And so that analysis has not been run as far as existing PCR, FCR within the priority context. Because there also are PCR and FCRs that have not availed themselves of the priority process.
Oh, yeah,
did not, I should say.
Yep, we did.
Did not previously.
Yep.
Including one that was done today, exactly. So those numbers have not been crunched. But I think that is something you could do in the context of implementation to know that what would be left remaining for priority applications at that point too.
Yes.
Potentially.
So, and we may need to revisit this just because I am concerned that if all of the priority RMD, if everybody who's entitled to priority MTC review has already been through the initial review and we're only applying this to people who come in the future and there isn't anybody coming in the future, then that does, I think in my mind, make this vote somewhat meaningless, which I don't want it to be.
My suspicion is that given that municipalities are continuing with their local processes, including some that have existing medical operations, that this would not be a moot policy, and that there will likely be applicants that could still avail themselves of the priority approach, but there also will be existing RMDs that may have availed themselves of priority status that would now not be eligible for that priority status as well.
Okay. All right. Thank you.
Okay. Any other requests for clarification, Mr. Executive Director? Do you feel comfortable that you have what you need to move forward?
At this point, I believe I have what I need to move forward. My intention would be to work with staff to implement this and probably, if there is a need for further clarification, I would certainly bring it to the Commission before acting.
Appreciate that. Okay. Thank you, Commissioner Doyle.
Thank you.
Commissioner McBride.
Once we identify the applicants who this would affect, can you circulate that information to us so that we have a sense of who went where?
Thank you. Anything else? Okay, I'm going to next ask Commissioner Title to lead us through the next conversation, which I think we have titled as considerations for economic empowerment and social equity applicants. Commissioner Title?
Thank you. So this commission, agency-wide, has made significant, I think, consistent progress with our recent decisions and regulations towards our mandate to include small businesses, communities disproportionately harmed by prohibition, and other groups. So it seemed like a prudent time to provide some considerations to those people from those groups because they have been being approached by predatory investors and those who would perhaps seek to use their status in an unscrupulous way. In our equity work plan that we passed that we discussed months ago, we talked about working with other states on issues that different jurisdictions are seeing in their equity programs. This was definitely one of them. So the purpose of this document is, without substituting our judgment in any way or encroaching on their independence and their own business decision making in any way, to provide some red flags to consider or warnings for signs that they might see that may make them want to think more carefully. And you'll likely see similar lists from other jurisdictions as well.
Thank you. What's your suggested dissemination approach for this?
I would actually leave that up to the staff's capable hands.
Okay.
Can I just
Go ahead, Mr. Feige.
Can I just ask a couple of questions? I don't disagree with this type of thing. I think that when it comes to scams, people who are the vulnerable population don't necessarily see it as in front of them when it happens. We see this all the time with the elderly, and we see this with people who come from certain populations. But do we know what the other states are doing? Are they handing out things like this? Or because I tend to think that something with regard to illegal activity goes through the Attorney General's office more so than us. So I'm just curious as to how it came about.
Yeah, totally fair question. I can't speak to other jurisdictions if they haven't come out yet because I don't want to be ahead of them, but I do believe something similar has come out in Illinois from the same office that is running the equity program, and I think that is probably the appropriate body because we see this on the ground very closely. And then also at the end, you'll notice where there is helpful links. To your point, there is a link to the Attorney General's office noting that if you think you've been a victim of fraud, that's the right place to file a complaint.
Thank you.
Commissioner Joel?
Thank you for preparing this. I think it's very interesting. I just have two brief comments. Number one, if we are going to hand this out, I would like to see some disclaimers on it in terms of this is not legal advice, et cetera, et cetera. And I'm sure our legal team is up to preparing some of those disclaimers. So thank you in advance for that, if it's appropriate. One other thing, because it actually just came up recently, I think should be included in here is with regard to economic empowerment applicants. In 2018, we had discussed a policy of how to maintain their status as economic empowerment applicants and the criteria, and I think that's very relevant to reminding them to maintain your status. You need to do this, and this, and I think that should be included in here because if they're being approached with deals that would be inconsistent with maintaining their status, they may make the educated decision that they want to go forward with the deal rather than maintain their status anyway. But I think it would be helpful to remind them, to maintain your status, you would need to do this. This is what the commission will consider when looking at it. So if I could just make that suggestion to incorporate that into this document, I'd like to see that.
That's an excellent point. I completely agree. And on the first point, it does say we recommend consulting with attorneys, but we can certainly add more disclaimers there at legal counsel's discretion.
Commissioner McGrath?
I just have one more suggestion. So we've seen plans that have been included in the management operations profiles where they've been wrong, right? They've been erroneous, and I think that in some instances applicants rely on advice from people who maybe are not giving them great advice. So this seems like it might be a good vehicle to maybe include a little bit of language there about we recommend consulting with qualified attorneys or other independent professionals, but kind of buttressing that with do your research also on who you're contracting with on that front too, because ultimately you're responsible for whatever plan you end up submitting to us, or kind of whatever you base your decisions on. It's owned by the applicant and the licensee, and so it might not be a bad idea to include that as well.
Great point.
Anything else? So what I'm going to suggest, Commissioner Title, if you're comfortable, is I do think probably should take a vote on this. The motion should include, if you're comfortable with the suggestions that were made by Commissioners Title or Commissioners McBride and Doyle, and also delegating to staff for dissemination, as we talked about earlier. Are you willing to make such a motion?
I am, but I did not write them down yet, so I just want to make sure somebody else wrote them down.
Mr. Chairman, if I may too, just food for thought here too is if the commission were to vote and adopt this would also lock the document as well. So if other things were to arise during the course of discussion, to amend it would require a commission vote as well. So just for, I guess, agility's sake, there might also be value to, I don't see policy in this so I'm just putting it on the table. I'm not.
Sure, no, I appreciate it.
Can I ask another question?
Yeah, go ahead, Commissioner Flanagan.
How do we plan to, I can't envision what this is going to look like. Are we creating pamphlets for people that are putting CCC on? Because what we have in front of us is just a white piece of paper. So I guess I'm sort of questioning, is this going to be like some colorful pamphlet that our social equity people are going to put together and we're going to disseminate in certain places? Is this a letter that's going to people who have been certified as equity? Is this, because I'm uncomfortable, one, we're trying to, this is just my government background that comes into play, is that, we're trying to do all these things for social equity applicants, but then we say, here, go consult with a lawyer. And the first thing I can imagine them saying is, I can't afford a lawyer. What am I going to do? And so I'm just trying to envision what this is going to look like and where it's going to be given out. And I know the staff can decide that, but if we put this in some sort of document that looks attractive, like a pamphlet that we can then distribute at events and things like that, to me that's different than just this piece of paper.
Commissioner Title, and then I'd be able to General Counsel as well. Commissioner Title, go first, please.
I appreciate you bringing that up, and I'd like to weigh in on it without being prescriptive, because I would like to leave it up to the staff. You are absolutely right, I think, in what you're envisioning, which is that the dissemination and the outreach piece of this is as important as the content. So you'll notice it's intentionally written with clear language, and especially for the audience of someone who maybe has just qualified and is just beginning the process. So I would leave it up to the communications professionals and the outreach professionals on the staff exactly how to disseminate it.
Commissioner, or excuse me, General Counsel, do you have comments? No? Okay. Well, you raised this. If you're comfortable going with the executive director just suggested, let's do it. Don't need a vote on it, and let the staff implement. I would very much want to make sure the staff. I want to make sure that the staff does take not just this, but the suggestions from Commissioners Title and McBride and Doyle. But, sure.
Just to capture what I do have is that discussion around a disclaimer relative to this itself is not legal advice. Adding a bullet relative to the if there is a recipient of this that is a certified economic empowerment applicant, that the Commission regulations do address the maintained status of that, given the fluid ownership, as well as to Commissioner McBride's point, adding that if you are relying on professionals for those, that they may want to also research themselves, and that doing so does not alleviate their obligations as a licensee or an applicant for compliance. So I think I've captured all of those, as well as relative to the materials. I think there would be this can be a versatile document that can be certainly cleaned up and disseminated with social equity program participants, and we do provide them packets at different meetings. I think as we also continue to evolve our web presence, I think this could also be a versatile page that might have a living document as well that could be a resource. So we would use it in a versatile way.
I'm fine with that. Commissioner Flanagan, go ahead.
Can I just get one very detailed, probably nuanced thing that I would suggest is that if we make this a living, breathing document where it can evolve over time, that we just put updated and by the date on the bottom so that people know that there are different versions of it, and they may not get their hands on the wrong one and it's outdated and
That's a
then
good point.
all of a sudden we don't have. So I'd rather this be a document that's just, it's living and it's able to evolve.
Okay. Commissioner Tyler? Thank you very much. I appreciate your leadership on this. We have two more things left on the agenda. First is that we are required legislatively to file an annual activities report with the legislature. I don't know whom to thank because I've read it. It's a very impressive document, but I'd like to know whom to thank because it was, I think, incredibly well done. So before we discuss it, can Mr. Executive Director tell me who to thank?
Sure. So this is a culmination of a lot of staff work, primarily actually led by our Director of Government Affairs, David Lakeman. However, each respective department head has contributed to their portion of this, and obviously, so through the leadership of David Lakeman, this was compiled.
Okay, great. My appreciation to David and the other members of the staff that were involved in this. This is something that, as I said, we are legislatively required to submit. I certainly do not want to submit it until it has been discussed and voted on by the Commission. And if there are any requested or suggested changes, get those embedded. So can I ask, are there any comments or concerns or requested changes with this document? I'd be surprised. It's a good document, very thorough. Then I would like to ask for a motion to approve this document and request the Executive Director submit it as appropriate, as required by law.
So moved.
Have a second, please?
Second.
Let the record show that Commissioner Flanagan made the motion to approve, seconded by Commissioner Doyle. All in favor?
Aye.
Commissioner McBride.
We look a lot alike.
You don't look a lot like, but you know, if I'm looking to what, this way, that my apologies. Let the record show Commissioner Flanagan made the motion to approve, seconded by Commissioner McBride. All in favor?
Aye.
Let the record show the Commission unanimously approved this. And again, my thanks to David Lakeman, the rest of the staff, and Mr. Executive Director. Obviously, you'll take the necessary steps to submit this appropriately. Thank you. The next and last agenda item is a report on positive impact plans. I am going to welcome our Director of Research, Dr. Johnson, Samantha Doonan, and our intern, who, are you still an intern, or are you like just coming back for a guest appearance?
I'm an intern until 5 p.m. today.
Okay, well, Jessica, first of all, I'm delighted to have you here. I really appreciate all the work you've done on this incredibly important topic, and I'm going to turn it over. I guess, Dr. Johnson, you're going to do an introduction, or are we just going to go straight to Jessica?
I'm happy to.
John.
Mr. Executive, go ahead.
So, thank you, Mr. Chairman. As you indicated, this is a special report from our research department. Jessica Hamilton, who will be presenting, joined the Commission as a Rappaport Institute Fellow over the summer. In that, as a fellow, her objective was to improve the governance of Greater Boston by promoting emerging leaders, stimulating informed discussion, and producing new ideas. Jessica chose the Commission to conduct her research assessing the intersection of public policy and social equity in the Commonwealth. Jessica is a second-year Master of Divinity student on the Global and Community Engagement track at BU's School of Theology. So we were very excited to host her this summer. Also very excited to, I guess, review and absorb today her research for the summer. So with that, Jessica Hamilton is happy to present her baseline review of the Massachusetts cannabis industry's required positive impact plans.
Thank you. Mr. Executive Director, Jessica.
Thank you, Chairman Hoffman, Commissioners Doyle, McBride, Title, and Flanagan, and Director Collins for your time and attention this afternoon. As Director Collins mentioned, I'll be presenting a special report titled A Baseline Review and Assessment of the Massachusetts Cannabis Industry's Required Positive Impact Plans. Also, as Director Collins said, I'm really interested in understanding what bearing the intersection of public policy and social equity have on these conversations of equity in the public policy landscape, particularly where equity seeks reconciliation for communities that have experienced harm. This special report is a product of my research and funding as a Rappaport Institute Public Policy Fellow, and represents a collaborative effort with the Commission's research department. In his 1963 essay, The Responsible Self, H. Richard Niebuhr expressed that the first job of a responsible person, in this case a graduate student in theology and ethics, is not to ask what should be done, or even the end goal or the desired outcome. The first job, according to Niebuhr, is to simply ask, what is going on? It is in that spirit of this framing that I am pleased to offer you this report, its findings, and relevant policy considerations. While the work falls outside of the scope of the Commission's research agenda defined in Chapter 55, I am of the belief that positive impact plans represent the primary means for industry participants to support social equity efforts and establish a meaningful attempt at addressing historical harm. They were also identified as an area of great interest to the Commission. The purpose of this report is to inventory the first full year of positive impact plans submitted to the Commission by all licensed marijuana establishments through a comprehensive assessment of the plans and surrounding processes. The research question guiding this assessment asks, to what end are positive impact plan activities oriented, or again, to provide a glimpse of what is going on. This question is important because it assesses the collective understanding of the purpose and potential of PIPs. We set out with 5 primary research goals for this project. First, to understand how marijuana establishments view their role in creating an equitable market. Second, to determine the types of activities marijuana establishments believe will most positively impact, disproportionately harm communities, and promote meaningful participation in the market. Third, to explore the varying interpretations of social equity as it pertains to the assessment of positive impact plans. Fourth, to investigate the need for and potentially connect the narrative associated with lived experience to available data quantifying the harm done to disproportionately impacted communities. And fifth, to provide considerations for equitable plans that align with the Commission's legislative mandate and restorative justice aims. This mixed methods exploratory study uses textual and stakeholder data review to understand the purpose and state of positive impact plans. Qualitative methods, including manual coding and software analysis, were used to examine PIPs, interviews, and social equity applicant free text responses. Quantitative methods were used in conjunction with qualitative methods to examine the frequency of themes and trends. To accomplish the stated research goals, multiple modalities of data were assessed. These include public documents, such as public meeting minutes and the Commission's guidance documents. Next, key stakeholder interviews were conducted with commissioners and analyzed for themes, consensus, and disagreement. Additionally, all positive impact plans submitted during the 1-year study timeframe, which represents again the first full year of submitted plans, were examined. Originally, 175 plans were extracted, but this was narrowed to only include 1 plan for each establishment, which resulted in a final sample of 72 plans. Lastly, data from social equity applicants and participants, including application questions and responses to a survey distributed at one of the social equity program seminars, were analyzed. I'll now present the baseline data. A review of the Commission's public meeting minutes demonstrates positive impact plans were a regular topic of public discussion. This discussion represents one avenue in which marijuana establishments were provided with informal guidance for their plans and the plans of their industry peers. From June 21, 2018 through June 21, 2019, there were over 15 instances in which the Commission publicly discussed and addressed submitted positive impact plans. Multiple themes were identified in these discussions. These included a need for clarification of an element in the PIP, a need for more information regarding the content of proposed educational activities, clarification on the ability of identified community organizations to accept donations from marijuana establishments, and questions about measurement for accountability. Additionally, the Commission often added conditions to provisional licensure based on concerns around a positive impact plan. The frequency of discussion suggests PIPs are a priority for the Commission, and the frequency of adding conditions to licensure suggests the Commission sees serious potential for PIPs to make a difference in affected communities and populations. and it further demonstrates a commitment to holding marijuana establishments accountable for their approved plans. To further understand the intent and scope of the positive impact plans, including where consensus and differences exist, key stakeholder interviews were conducted with all commissioners. We found there's consensus among key stakeholders about the harm previously caused by marijuana prohibition and enforcement that still actively impacts the lives of targeted communities and populations. Likewise, all key stakeholders stated that they have a role in ensuring the creation of an equitable cannabis market and share the intention of setting up an equitable market that is sustainable in the long term. There was also consensus that PIP activities which provide economic benefits to cohorts identified for impact are encouraged. There was clear discouragement of strictly donation-based activities or activities that provide industry with an opportunity for marketing or self-promotion. Several themes also emerged that illustrate differences. Key stakeholders define social equity in varying ways. For example, if placed on a continuum, key stakeholders define social equity as ranging from acknowledgement of past harm with a commitment to addressing that harm, to equality of opportunity without attachment to equality or guarantee of an outcome. Different definitions may indicate a difference in approach to achieving the stated ends. However, common themes also emerged in the definitions. All stakeholders identified that social equity was related to access and opportunity. Stakeholders identified a range of purposes for the PIP, indicating a lack of consensus. These purposes mainly fell into two ideologies. The first is that of goodwill or a community service ideology. Several stakeholders understand the purpose of positive impact plans is to encourage businesses to enact and sponsor community service activities. Activities that work toward the purpose include quietly sponsoring community events and workshops or seminars to educate the community about the industry and promote responsible and safe use of cannabis. A second identified ideology is that of restorative justice. Several stakeholders understand the purpose of the PIP is to work to address the harm caused by marijuana prohibition and enforcement. Activities that work toward this purpose include providing cannabis entrepreneurs from communities disproportionately impacted with business training, mentoring, funding, networking opportunities, and opportunities for training and employment within the industry. The positive impact plans were qualitatively coded to identify whether they include the priorities established in the research goals, as well as the key themes that emerged from key stakeholder interviews. As you can see in the picture behind you, we employed a qualitative hand coding process. It's kind of intensive. In the guidance document for positive impact plans, the Commission states plans should include a goal or goals and metrics for accountability. 85% of the plans assessed for this research included a goal or goals, and 83% included metrics. The guidance also clearly states a diversity plan and a positive impact plan are separate documents with separate goals. 63% of plans demonstrate an understanding of the distinction between positive impact plans and diversity plans, representing a spot for improvement. The guidance also identified 5 cohorts that positive impact plans may target, which include persons living in an area of disproportionate impact, or ADI, social equity applicants, economic empowerment applicants, people with a past drug conviction, and people who are the child or spouse of someone with a past drug conviction. 93% of plans targeted at least one of the required cohorts, but we do want to point out that many plans were limited to only cohort 1 or people who reside in an ADI. Some plans demonstrated a lack of knowledge that there are 4 other identified cohorts they could choose to target. This may be an area to emphasize in any future guidance updates. Notably, only 38% of plans define social equity in some way, and 51% include language that demonstrates understanding of the historical narrative associated with marijuana prohibition and enforcement. All submitted plans included proposed activities. However, proposed activities range in clarity, substance, and commitment. For example, a number of plans offer a list of activities with no firm details or specific implementation explanations about the implementation of those activities. Additionally, plans varied widely in their approach to positively impacting communities. While many plans included activities that were economic in nature, those activities ranged from grant funding and accelerators to donations to local community organizations or merely the opportunity to apply for a job. In some cases, donations were made to social service agencies and disease-focused nonprofits that do not directly target the priority cohorts identified by the Commission for Impact or the cohorts identified in the respondent's plan. Lastly, a number of entities included conditional language in their plans to indicate their ability to implement the proposed activities depends upon the success of their business. The next data source came from social equity applicants and participants, who are one of the identified cohorts that PIPs can choose to target. We would like to acknowledge and thank the social equity applicants and participants who generously shared their insights, stories, and experiences for this project. This first findings are from a 3-question survey administered by the research department to invited social equity program participants to better understand their views of the positive impact plan. A total of 56 social equity program participants completed the survey in the summer of 2019. 82% of respondents were from or planned to open a business in an area of disproportionate impact. Participants were asked about their perspectives of the obstacles faced by communities disproportionately impacted by the war on drugs and identified many obstacles, including a lack of resources, law enforcement related obstacles, including criminal records and bias, political navigation challenges, generational poverty, education, job training needs, and stigma. Participants were also asked which activities they would advise marijuana businesses to initiate or fund, and respondents were asked to select their top 3 answers from a list of answers developed from activities identified in the reviewed positive impact plans. 73% of respondents recommended grant funding, 57% recommended low-interest loans, 43% recommended accelerator or incubator programs, 34% recommended public information or education sessions about marijuana in the industry and disproportionately harmed communities, and 27% recommended job creation. Respondents could also select other and write in a response for this question. 11% of the participants selected other, and these participants advised the following: funds to public education, low-income housing or down payment program, record sealing and expungement, responsible consumption, application process priority, mental health counseling, and trade school investment. These responses could elucidate additional barriers and the needed safety nets, or the safety nets needed from persons targeted by the war on drugs in attaining additional economic opportunities. Thank you. The social equity application was also utilized as a data source. Applicants were asked to indicate any and all barriers to entering the cannabis market from a list of identified barriers. Applicants could also choose other and write in a response. 73% of applicants identified economic factors as a barrier to entering the cannabis market. Regulations were also cited as a major barrier. 58% of respondents cited government regulations as a barrier, while 52% of respondents cited city or town regulations as a barrier. In addition, 40% of respondents cited cited racial discrimination and prejudice as a barrier they have experienced in trying to enter the market. Next, there was an open text field labeled "Explain Here," providing applicants with an opportunity to offer more details about the barriers to entry they've personally experienced. Many of the write-in responses were very specific and offered a glimpse into the lived experience of the social equity applicants. Key themes that emerged included lack of access to funding, past drug-related convictions, stigma, training needs, and having a background from impoverished neighborhoods targeted by marijuana prohibition and enforcement. Notably, one respondent who wrote, although their neighborhood is now not listed as an area of disproportionate impact, the neighborhood was, in their opinion, heavily impacted by drugs and the war on drugs. This may imply that varying and changing geographic policies are not fully accounted for in the current ADI specifications, and this may need to be reassessed for future applicants. This sentiment concerning changing landscapes was also echoed in other responses and key stakeholder interviews. Social equity applicants were also asked to answer the question, what does social equity mean to you? After articles like the word A and the were excluded, the 100 most commonly used words from the 399 responses were queried to understand the words that social equity applicants used to define social equity. If you'll look at the word cloud on the screen, you'll see that the larger and more bolded a word, the more frequently it appears in cohort responses. Words most often found included industry, opportunity, community, people, business, and chance. A selection of responses that highlight themes from the question, what does social equity mean to you, provided by these applicants are provided on the screen as well. I'll read the first one aloud. The social equity applicant writes, social equity means to me a sincere, concerted effort to correct wrongs in areas of past societal and systemic inequities in all areas of our lives, especially in regard to economic opportunities and the criminal justice system, by affording support for those who have been impacted by past inequities so that they can receive opportunities that those with more privilege have taken for granted. This study, like all research, is not without limitations. Due to time constraints, stakeholder interviews could only be conducted with commissioners. Future research could interview current and prospective marijuana establishment owners to better understand how they view the positive impact plan, their plans for compliance, and any barriers they experience to compliance. Qualitative coding methods used to analyze positive impact plans are subject to those limitations inherent in qualitative work. Some subjectivity is required throughout the coding process. Therefore, qualitative work can be impacted by researchers' background and bias. To minimize bias, two coders from the research team independently coded all plans, with the lead researcher completing a final review for consistency. Due to time constraints, only word frequency analysis rather than a full qualitative analysis of social equity application responses and context could be conducted. Lastly, this research provides a baseline assessment of positive impact plans. It does not examine the extent to which businesses complied with stated aims and activities as a regulatory condition of license renewal. Future research should examine compliance more broadly, and in particular the effectiveness and impact of stated activities for each of the marijuana establishments and marijuana establishments in aggregate across the Commonwealth. After examining findings from the range of data sources presented, a number of key takeaways emerge. In regard to the positive impact plan purpose and social equity, we find key stakeholders identified a range of purposes for the positive impact plan. There was consensus across key stakeholder interviews about the historical narrative of marijuana prohibition and enforcement. However, there are differences in defining social equity. Only 38% of positive impact plans define social equity, and approximately half include language that demonstrates an understanding of the historical narrative associated with prohibition. Social equity applicants' free responses about the definition of social equity often include industry, opportunity, community, people, business, and chance. Free responses included a range of themes such as concerted effort to correct past wrongs, balancing injustices from the war on drugs, investment, and a chance to heal. In regard to positive impact plan activities and economic activities, we find that all positive impact plans included proposed activities, but the activities range in clarity, substance, and commitment. Multiple plans included conditional language indicating their ability to implement activities depends upon the success of their business. We find consensus across key stakeholders and social equity applicants that PIPs should include economic activities, but there is a need for clarity around the desired economic activities. Many positive impact plans include economic activities ranging from grant funding and accelerators to the opportunity to apply for a job or donations. Additionally, some donations were made to organizations that do not directly target the cohorts identified by the Commission. And when social equity applicants were asked which activities positive impact plans should include, the top answers were economic, grant funding, low interest loans, and accelerator or incubator programs. And finally, in regard to positive impact plan adherence to guidance, we find the Commission clearly defines a difference between the positive impact plan and the diversity plan in public documents, whereas 63% of submitted positive impact plans demonstrate knowledge of this difference. The Commission publicly states positive impact plans should include a goal and metrics for accountability, and 85% of plans include a goal and 83% of plans included metrics. The Commission also identified 5 cohorts that should be targeted in the PIP, and most PIPs target at least one of the cohorts, mainly cohort number 1, those who reside in an area of disproportionate impact. Referring back to the initial ethical question of determining what is going on, based on the data assessed, this research infers that there is non-consensus among stakeholders on the purpose and goals of the positive impact plan. This may impede the ability of potential impact, the utility and potential impact of positive impact plans. This may impede the utility and potential impact positive impact plan activities could provide the Commonwealth in positively affecting the 5 specified cohorts. Based on the baseline data findings, we have several technical and substantive policy considerations that may help the Commission transform the collective understanding around positive impact plans such that everyone is speaking the same language to accomplish the same and agreed upon goal. There are 3 technical policy considerations. First, the Commission could update the name of this requirement to offer clarity on the purpose and aim. The activities listed in submitted plans, for the most part, are positive in the ultimate sense, but the activities are not all aimed at the particular problems that this Commission is trying to address. Renaming the requirement could offer us fresh perspective to refocus plans to better address stated goals and ensure there is a focus on the 5 specific cohorts of impact. Second, if the Commission decides to rename this requirement could be more clearly defined. The definition could include the plan's purpose, the 3 required sections of the plan, and the targeted cohorts. Third, the Commission could issue separate guidance for the positive impact plan and the diversity plan. There was much confusion identified in reviewed positive impact plans regarding the terminology diversity versus equity. So separating the guidance for the PIPs and the diversity plans may facilitate a shift in understanding the distinct activities that should be included for both. We also identified 5 substantive policy considerations. First, the Commission could define a common meaning of social equity and guidance to provide clarity among all stakeholders in the public. Second, the Commission could prioritize in guidance the sentiments, reflections, and perspectives of those most affected by marijuana prohibition and enforcement, including the top 3 activities identified by social equity program participants. This could be done through an example list of activities to include in guidance driven by suggestions from affected persons. The development of future PIPs could be required to be community-driven, such that through a public meeting with the proposed ADI or the proposed cohort to be impacted. Additionally, the Commission could emphasize focus on addressing harms to specified cohorts, not just geographic locations. This may shift in fundamental ways over time. The Commission could also address the difference between the activities aimed at equity versus those aimed at community service, since the latter do not recognize harm in this context. In general, society is oriented to community service, which is different from the foci of activities proposed in positive impact plans, which are specifically aimed at addressing harm to 5 specified cohorts, including those residing in specific geographic locations. This would help facilitate an emphasis on the experiences of the identified cohorts with the goal of positive impact plans, so that the goal of positive impact plans is not missed. For example, consider the reflection that I shared a few slides ago of one respondent who wrote that although their neighborhood is now not listed as an ADI, the neighborhood was, in their perspective, an area heavily impacted by drugs and the war on drugs. How can the PIP mechanism ensure industry's efforts capture and positively impact individuals like this one? Third, to address harm, it would be helpful to collectively understand how marijuana prohibition and enforcement played out in Massachusetts. In other words, to tell the Massachusetts story, to offer important contextual information and data such that there is a collective understanding of the harm to inform PIP proposals. Social equity program participants and applicants are an effective primary data source on the lived experiences and perspectives. However, more research and data are needed to quantify the harm done in identified cohorts and communities and to provide information on the policies enacted, sanctioning, prohibition, and enforcement. If taken in context together, the implication of policy considerations 2 and 3 is that it is important to center the human experience and experiences of particular cohorts in all of this, not just communities defined by geography. Fourth, the Commission could update the guidance on equitable cannabis policies for municipalities to include information on the history and impact of prohibition and enforcement on disproportionately impacted communities and the types of activities that the Commission encourages to address those harms. Fifth, the Commission could consider future analysis to update the identified areas of disproportionate impact. These analyses could take into consideration the demographic changes and forced migration patterns of populations, such as gentrification, movement based on the availability of work in a community, or movement based on public policy, to more accurately identify cohorts of populations, not census tracts and zip codes. That concludes my presentation. Thank you for your time, for listening, for humoring me this summer. I'm happy to take any questions that you may have.
Thank you, Jessica. Are there questions?
Mr. Chairman.
Commissioner Flanagan.
First and foremost, I would like to thank Jessica for her work. I know that trying to track the 5 of us down at any given time and trying to talk to us about a variety of issues is difficult. And so we really appreciate all the work that you did this past summer. And I know that I probably can speak for the staff and the commissioners of saying we wish you the best at school. You really did a great job for us, so thank you.
Thank you.
The one thing I will tell you is that you're wrong about this being outside the scope of Section 17. I think we in the former legislator we used to put in including but not limited to, and this is the but not limited to, because I think really what this speaks to is that you're helping to shape future decisions made by this commission, and so you are absolutely within your purview under Section 17 of Acts of 55 to do this research, and so we really appreciate what you brought to the table with this. Just a couple of comments is that, you know, we started 2 years ago, 5 people, 5 cubicles, we can't talk to each other, open meeting laws, which again are meant for transparency and not productivity, which means we have a million balls in the air. We're trying to, you know, take care of social equity applicants. We're trying to do positive impact plans, diversity plans. By the way, we have to license entities. The poor farmers want to get things in the ground so that they have the next grow season. And I really think that we had a very broad population of people that we're trying to address, but we're being very prescriptive in the way that we're doing it. And so it would be easier if it was the opposite, if we had a very prescriptive population of people with a very broad sense of how to do that. Having said that, the positive impact plans, I think, were intended to be beneficial to those beyond people seeking to be part of this industry. Not everybody's going to want to be part of the marijuana industry. But there are communities that have been negatively affected by the enforcement of the drug laws, and we recognize that. And the fact that we have 351 cities and towns that independently have initiatives, programs, services, depending on where they are in Massachusetts, really we're trying to be a little cognizant of that and allow the applicants to be very creative in the ways that they go about this. Having said that, I can tell you that you know, your consideration number 5, which is not up there anymore, but we have just begun discussions to take another look at the identification of areas of disproportionately impacted areas. I think that I can say for myself that when the list came out, I was a little concerned that there were some cities and towns missing. And then I was also concerned about why others were added. And I think that's where, unfortunately, Pharmacanis got in the middle of it when they were giving 2 oyster festivals in Wareham, and we also weren't thinking of maybe some communities in the Merrimack Valley that could have needed our services a little bit more. So the balance wasn't there. And, having been in the legislature when the recession happened, 2009, 2010, 2011 were not good fiscal years in this state. We had the recession hit us before anyone else in the rest of the country, and I think the numbers reflect that. So you're right in your assertion that some cities and towns need to be on this, and others don't need to be on this, but we are where we are. So having said that, I really appreciate the fact that you put this into a manner by which we can then go back and have discussions and really change the way that we handle positive impact plans, or whatever we might call them in the future. So, I really think that it's important for us to be able to see this, and the public to be able to see this, because I know that when an entity comes before us, they know probably 9 times out of 10 I'm going to send the impact plan back, because I don't think it's enough. And I think from my perspective, I could be a little harsh in the fact that I want these plans to impact more people than I think people envision. And so I really want cities and towns to be positively impacted by this in a whole array of areas. But to do that, we may have to educate entities a little bit more about the Commonwealth of Massachusetts, and they may want to learn from us about what different programs there are in different cities and towns across the state, and the different geographical locations and what those bring to the table. So thank you very much for this. We really appreciate it. I know that we have some work to do, but now that we got this, I think we're good.
Thank you, Commissioner Flanagan. Can I say that as hard as it is for me to meet with each and every one of you, it's easier than you all meeting with one another.
Because we're not allowed to.
Yeah.
Other comments, questions?
Just gratitude.
I think that was first of all incredibly eloquent, but I don't think I have anything to add to that other than to just communicate my gratefulness as well. You've given us a lot to think about, a lot to work on, and we really deeply appreciate it.
Thank you.
Jessica, you did such a wonderful job. I'm so grateful to you. We're also grateful to you for the expertise and the insight and the commitment you took. If you read the report and you watch your presentation, it's clear that you did not take any shortcuts, and you really wanted to give us practical advice. And I feel like with your unique academic experience and your area of research interest, we got so lucky. It seems like you were made for this job and no one else could have done it. So really, really thank you.
Thank
you. And I learned a lot. And so I want to ask you a few questions before we lose you at 5 p.m. So you really incorporated, I think, 2 maybe unwritten but really clear values of the commission, and one of them is centering the voices of the affected people, and us not going out there and telling them this is what you need, but rather us listening because they know. So I appreciate you including that. What would you suggest in terms of the plans that are really good? We want to give them positive reinforcement, but in this format, it doesn't make sense to say, hey, this applicant's plan was really good. Is it as simple as just making them public and letting them get public scrutiny, or do you have other ways that you would suggest encouraging the good ones?
A couple of things. I think your public discussion, as someone who read all of your meeting minutes for well over the past year, your public discussion is robust, and I would ask that you continue or consider continuing discussing the positive impact plans and what precisely you're looking for the goal that you all establish publicly, keeping that light on the positive impact plans, keeping the pressure on what it is that you're looking for in the public domain, I think would be really helpful. The market responds to your guidance, both informal and written. I did notice that in the waves of plans that I was reviewing, the resubmissions, they respond to your guidance. They're watching, and so I think it's important to keep conversation about what you want to see in positive impact plans in the public domain. Second, I think just as an immediate reaction, publishing some of the plans does make a lot of sense. I think, I had a chance to look at them again over waves of their submissions, and they are very telling of where companies are, what they value, and where they see themselves in the market, and where they see or how they understand their responsibility with this particular provision. And so I think you can share that.
The other value that you incorporated was the commitment where the end goal of these plans is to have an impact that we can measure and communicate, and not to have, theatrics or words on the page, because that wastes their time and wastes our time too. When it comes to the measurement, our general rule of thumb has just been you have to have some kind of measurement that we can then come back and ask for. Would you recommend anything more specific in what measurements we are requiring?
Commissioner Flanagan, based on some of the plans that I read that were really ambiguous, I think just giving focused feedback on how they can have detailed metrics that they want to meet. Like, a lot of people put data out there that was just like, how are you going to do this? And then some people were more measured and said, in year 1 we want to do this, in year 2 we want to do this, in year 3 we want to do this. I think having them stage their data in that way is great, or their plans in that way is great, but just having them be specific about what it is that they plan to do. I wish I could shout out an example for you. I'm trying to think very quickly. I liked plans that said in year 1 we're going to do this, in year 2 we're going to do this, or that we're focused on something very specific such that we can come back and tell you about it. Does that help?
Absolutely, yes, thank you. Okay, 2 last questions. Many of the companies that have multiple licenses, they'll have 5 different licenses with different business types, but then they'll just have one positive impact plan. Would you suggest that they should be different for each license? Or do you think it doesn't matter?
I don't know that that matters as much as the substance of the plan. If you have 5 different licenses, but the substance of your plan is that you're going to use your resources to make an impact in a certain community or an identified cohort, then I think that is what matters. I think it's just having something substantive, concrete, specific, and measurable that matters, not how many that they have.
Okay. Did you have anything in mind when you suggested a different name?
I think, yes. I
Did
think,
you share it?
yes. I think, if you read the guidance, it literally says, establishments for provisional licensure should submit plans to positively impact disproportionately impacted communities. And as a theologian, I immediately saw that as like, oh, you're repairing harm. Like, that's where my mind went. I think you should call it what it is. If you're repairing harm in this context, it looks like equity, right? So calling it an equity plan, calling it a social justice plan might help orient the market to what they're actually supposed to do. The number of times that people put diversity metrics in the positive impact plans was far greater than I thought it would be. But I think we have a running start on diversity that's been in the public sphere for like a long time. Equity is a new conversation. I think having it be clear for people, defining it, calling this what it is would be immensely helpful.
So we are allowed to talk in pairs,
Okay.
of course. So Commissioner Flanagan and I discussed your report. Obviously, we're very impressed with it. We would like to volunteer to take a first stab at implementing the considerations into a new version of the guidance.
That's fantastic.
Great.
Thank you.
Thank you. Anything else?
Can I just add that
Absolutely.
I am so grateful to have been a part of this team this summer as well. I think you all do thoughtful and engaging and really important work, and I have learned so much from each of you, particularly within this context. I didn't know anything about cannabis, and so I appreciate you being welcoming to someone who is interested in theology and cannabis.
I think it's been a mutually beneficial relationship, so thank you so much.
Thank you.
Can I see the clicker back? And so that means we can still talk to you for the next 2 hours and 20 minutes?
Yes.
Good. Don't leave then, please.
Well, technically, we have her email address, so she's not going away.
Okay,
She just doesn't have to answer us.
That's for the next 2 hours and 20 minutes, she does, that's my point. There's no business that I'm aware of that I wasn't aware of at the time that the agenda was published. So before I ask for a vote on adjournment, our next meeting is November 7th. Place to be determined, 10 a.m. And then again, as part of the monthly rotation, the next meeting will be December 5th. We should have a location hopefully shortly. Obviously, as soon as we have one, we'll communicate it. There being no further business for the commission, can I ask for a motion to adjourn?
So moved.
I always get the quickest response on this particular request.
Because you
for a motion.
asked. Just say it. Let's go.
Second?
Second.
That's right, Commissioner Title made the motion to adjourn. Second by Commissioner Doyle. All in favor?
Aye.
All right. We are adjourned as of, let's see, right, the commission has voted for adjournment. We are adjourned as of 2:40 on October 10th, 2019. Thank you very much. And for those of you in attendance, thank you very much for being here.